This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we explain why no coverage exists to repair or replace construction defects in Massachusetts, and why construction defects standing alone do not constitute property damage, the subject of a commercial general liability insurance policy. The Appeals Court of Massachusetts was asked to decide whether the cost of repairing or removing construction defects constitute damages because of property damage within the meaning of a commercial general liability policy. In Lawrence H. Lessard versus R.C. Havens and Sons, the Appeals Court of Massachusetts on August 14, 2024, was faced with an issue of what it called first impression in Massachusetts, whether construction defects are property damage as designed and defined in a CGL policy. In the underlying action, Lawrence H. Lessard and Jennifer A. Meshna, the homeowners, sued their builder for the faulty construction of their home. At a trial, a jury found numerous construction defects and awarded the homeowners damages. Meanwhile, Main Street America Assurance Company, MSA, the insurer that issued to the defendants R.C. Havens a commercial general liability policy covering the relevant period, intervened in the action and sought a declaration that it did not have a duty to indemnify R.C. Havens under the policy. As the project neared completion, the homeowners began to discover substantial issues with the quality of the construction. A number of problems compromised the structural integrity of the home. A portion of the structural post that was supposed to run from the roof to the basement was missing, and partition walls, sill plates, and support beams were installed incorrectly. As a result, some partition walls were improperly weight-bearing. The jury in the underlying action awarded the homeowners $114,159 for the structural defects, $14,207 for the roof deck, $37,000 for the siding, and $52,500 for the metal roof. The jury also awarded the homeowners $925 for problems with the home's insulation, $18,036 for mold damage, $8,430 for loss of use of their home during repair work, and $27,276 for costs of investigating the defect. On the motions for summary judgment, a security judge found for MSA on all issues that it owed no duty to indemnify the insured. As a general principle, the insured, or the individual seeking coverage, bears the initial burden of proving that the claimed loss falls within the coverage of the insurance policy. If the insured meets that burden, the burden then shifts to the insurer to show that a separate exclusion to coverage is applicable. To resolve the homeowner's appeal, the appeals court only needed to address whether the losses constituted property damage within the meaning of the policy. Policies like the CGL issued by MSA define property damage as physical injury which suggests the property was not defective at the outset, but was rather initially proper and later injured. Because faulty construction is defective at the outset, the cost of repair are not claims for property damage. For example, an improperly installed window would not be property damage, but resulting water damage to the surrounding wall would be. The appeals court held that the construction defects, without more, do not constitute property damage within the meaning of a commercial general liability policy, and the summary judgment record established that the underlying jury verdict awarded damages only for the costs of repairing or removing the construction defects themselves. Since there was no evidence that the construction defects caused injury to other property, MSA had no duty under its commercial general liability policy to indemnify RC Havens for the final judgment, because construction defects standing alone do not constitute property damage within the meaning of a commercial general liability policy, and therefore the judgment was affirmed. In my opinion, liability insurance is designed to protect an insured against fortuitous events that cause direct physical loss or damage, and damage to the property of persons other than the insured. When there is no direct physical loss, there can be no coverage, because the only damage was the construction defects that were never undamaged and that did not cause damage to other property. Therefore, the builder must pay from its own funds the judgment, if he has any. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll have access to the more than 4,850 blog postings. You can also subscribe to the videos. They're also free. And if you like the videos and or the blog, please tell your friends and colleagues about the blog and the videos so that they too can subscribe. And if you're interested in more detail about insurance, insurance claims, insurance law, insurance fraud, please consider, for a very small fee, subscribing to my Substack publication or checking out my books at the Insurance Claims Library with a link on the blog posting. Thank you for your attention.